trust me. All right, well, we are about 5 minutes late from when this meeting was supposed to start, so we are starting the legislative committee meeting at 11:37. Roll call, please, Sandy.
Member Chaplin.
Here.
Member Desart.
Here.
Member LaPlante. Member Renahan.
Here.
Member Salmon. Member Zay.
Here.
All right. I'd like to make a motion to approve the minutes for the Legislative and Governmental Affairs Committee meeting on Tuesday, February 22nd, 2022. I made the motion. Chaplin was the second. And roll call, please.
Member Chaplin.
Aye.
Member Desart.
Aye.
Member LaPlante. Member Renahan.
Aye.
Member Salmon. Member Zay.
I know, sorry, I don't know what we're voting on.
All right, so that passes. And next up, the start of the show, Member Chaplin asked that we talk about enhanced
Oh,
penalties.
the public comment? We do
Oh,
that.
thank you, public comment. I'm
No,
sorry.
we don't, but thank you.
Liz. Enhanced penalties for threatening public officials or public employees in Illinois. And let's start out with Connor to talk about what's currently in place.
So just generally speaking, historically, the state's attorney's office has introduced dozens of bills over the last 10 years or so that seeks to either enhance penalties, make offenses non-probationable, which we've been told is effectively the same as enhancing a penalty, and particularly automatic transfer of juvenile offenses such as carjackings and armed vehicular hijackings, all with no success. There's a certain portion of the legislature that is absolutely opposed to any sort of enhancement. And that's also typically the position of the American Civil Liberties Union, which is very much opposed, I think, as a matter of practice to any such amendment, to the point where I would say there's a clearance direction from the legislature that that's not something they've sought to take up. And as a result, I think we've seen very few of our legislative efforts on that, in that vein, pass.
Why
over the
is
last
that,
several
Connor?
years.
Why are people against enhancements?
I think there's a variety of, and I'll actually ask Mr. Valin if he has an opinion on it, because my general thought.
And then we are honored to have our state's attorney, Robert
Thank
Berlin,
you.
with us
Good
today.
morning.
Good morning.
So I was present February 11th, 2019, when the governor announced his Justice, Equity, Opportunity Initiative. And part of that initiative is to move away from prison sentences. And they've been very public with it. And in that initiative, they state that punitive methods have been unsuccessful. They're moving towards more restorative, inclusive, and cutting-edge practices and programs that result in true justice and equity. So that is one of the reasons why we've been very unsuccessful, even getting any penalty enhancement called in a committee. And we've been told there's no appetite for any penalty enhancement.
State's attorney, you have your own lobby for Springfield, right?
Yes.
If you'd ever like to join our, you know, we have your initiatives put on the county's legislative agenda as well, just let Cheryl know. But why are people in Springfield not interested in enhanced penalties for elected officials? I think of people like Gabby Givers, who was shot at a public event. So why is there no appetite for that?
I'm just saying, in general, there's no appetite for penalty enhancements. That this is, they're moving away from prison. Prison population in the state has gone from 47 to 27,000. So, obviously, there's a lot of changes in the criminal justice system that have taken place, more that are coming as of January 1st. I'm not saying it's impossible, but that's just the climate right now.
Do you have a whole presentation you wanted to present? Or did you just?
I was just going to, you know, kind of talk about what the penalties currently are.
Yes, thank you. That's what I
Sure.
wanted to know. Yes,
Sure.
thank you. Just a point of clarification. I'm just a little confused. Is there currently a bill we're discussing adding, or are we just discussing the legislative merits of this?
Legislative committee member Chaplin asked for this presentation.
So could you clarify?
Well, because I would like to see what the penalties are, for threatening an elected official, and then see, do we want to talk with our legislator to see if we want to push something through, try to push something through that would enhance them or not. I don't know, because I really don't know what the penalties are.
So
Did you
I
not
would-
look
or
them
that-
If I could just clarify.
Well, do you know what the
purpose-
penalty, I don't
I'm
really
sorry,
know what that.
If I could clarify the purpose of this meeting,
Mhm.
the legislative committee is the parent committee pertaining to letters of federal and state legislative policy.
Mhm.
It's for us to develop and analyze legislative initiatives, not to create our own. Develop and prioritize the state's annual, legislative agenda. We're not legislators, so I just don't think this is.
Well,
very-
we've introduced bills, right, Cheryl, to Springfield, the county has introduced, haven't we taken our own
Related to county business.
bill?
I would
Yeah, we're
presume.
kind of.
On bills, the state attorney's office has done the penalty bills. but-
Right.
All the laws come from our state legislature.
Right, well, I would like to know what the penalties are, and I think it's important that we know.
But if you're uncomfortable with this, you're welcome to leave. Member
Or-
Sullivan. Or if you'd like to be an obstructionist. you're welcome to
No,
leave.
it's not obstructionist. I just like to do our jobs.
Zay, member Zay?
I just, I know why you're bringing this up. You want to do it, but I want to know where your concern was when our county board chairman was threatened and convicted by somebody of threatening him, threatening him and his family, but there was no outrage at the time.
I
When we
didn't
talk
know
about
when
politics
this
on
happened.
this.
Sorry, Clarify, when did this happen? I didn't hear about this.
When did that happen?
This
Probably
chairman.
2 years
Cohen?
ago?
Probably
We had to
2
start
years-
locking our
2
doors.
years
It is-
ago.
That's why our doors are locked now. That's why we have added security up front. That's why you have everything else. I mean, to where the chairman was arming himself and we had guards on him 24/7.
And his
Yeah.
family?
And this person was convicted too, if I'm not mistaken. He pled guilty.
And Bob Schulstrom was also.
But where was this outrage then? But
Well,
now all of a sudden because it's one of your colleagues that was threatened and a friend,
Well, I
now all of a
think
sudden
to
we gotta
the,
take priority of
I
this
mean,
or?
I don't know if you heard any of the threats that were made, or if you listened to any of the, how really vile those threats were, and how it really turned that whole office upside down, and the emotional toll, just like it had on the chairman. And also, it's not only that, but it seems like people feel more at liberty to threaten elected officials right now. We saw it with the election, not here so much, but throughout the country, where elected, poll workers and election workers were being threatened, and county clerks across the country were being threatened, and we had the insurrection on January 6th. I mean, it just feels like people seem to maybe have lost some type of respect maybe for elected officials, that they feel that they can go and threaten them.
Or in general, in law. I
And
mean,
here's
and
the,
maybe you see it as we've seen it, that
well, here's,
the thing that's happening in the state of Illinois is the opposite direction of what you're talking
well,
about.
here's the thing too. If we threaten elected officials, right, people want to threaten them, then it's a threat against our democracy, because you may not have anybody want to run for office because they're afraid that they are going to be subject to these threats. So
It's part of the job.
it is-
Bob knows they have an investigator and somebody who's been sending me very odd stuff, and it's part of my job. It has
Well-
not even to the extreme that the representative went through,
right,
but
right.
this is part of it. But again, we agree with you. Why is there not enhanced penalties? Why are there changes? Why did the safety bill make it a misdemeanor? Why don't you stand with us and let's hear about it and let's move for
Well, here's
better
the
penalties.
bigger umbrella is this, whenever anybody asks me, could we hear more about this? I'm going to say yes. And all of our laws come from the legislators, so this is legislative in the big umbrella. And we brought State's Attorney Berlin here to tell us what the current laws are for threatening elected officials. So let's let State's Attorney Berlin make his presentation. Thank you for being here.
Thank you. So threatening a public official is a class 3 felony. What that means is if sentenced to penitentiary, it's 2 to 5 years, but it is also eligible for probation. It's not one of the offenses that is considered non-probationable. A second offense makes it a class 2 felony, which means it's 3 to 7 years, but again, eligible for probation. I would point out that as of January 1st, 2023, when the state gets rid of cash bail, under no circumstances can anyone charged with threatening a public official ever be held. They will always be released. Because it's not a forcible felony, and it's not one of the felonies that's listed in the statute. So that's where we stand. The Stephen Bona case was a case that we prosecuted. It was a jury trial. About
It was a Stephen Bona case,
Stephen Bona
was the one who threatened the chairman?
was the one who threatened Jeannie Ives
Oh, Jeannie Ives.
with 2 phone calls. And there were numerous motions challenging the constitutionality of the statute that we prevailed on. It was a jury trial. He was convicted. Judge Piquel sentenced him to conditional discharge, which is a non-reporting form of probation. But the case was affirmed on appeal in a published opinion, and it actually gives us guidance to what is required to prove one of these cases. And it's not as easy as you think, because the courts have said it's not just a threat, it has to be what they call a true threat. And true threats, in the Bona opinion, are we have to prove that the person that transmitted the threat did so with intent to issue a threat, or secondly, with knowledge that it would be viewed as a threat. And that's the definition of true threat. So
But
that's
I
what's
mean, the
required.
true threat, I don't know, I just want to have a conversation. The true threat is not just the physical threat, but also the terrorism behind the threat. I shared with these guys that when I was at Channel 5, I had a guy call me and say, hey, is this John Desart? I said, yes. I said, who's this? I said, I'm the guy who's going to slit your throat. I said, would you do that? Why would you? And he hung up. But after that, and I had Chicago police come and check out my car, and then Aurora police come and check out my home. But for months after that, I felt true terror. You know, I had a toddler at the time, and I was afraid, you know, he was going to find me in a puddle of blood. So I mean, I wasn't actually hurt physically, but it was definitely terrorizing for months.
I don't disagree, which is why we take these cases very seriously. Which is why in the instant investigation, our office is involved, and they have been involved from the beginning with the state police investigating. So any threat to a public official, we've been very consistent prosecuting those cases. I'm just bringing this up because the courts look at the First Amendment, protected speech versus what constitutes a true threat.
What happened in the case of the chairman's,
That was a plea of guilty and a sentence to our mental health court.
mental health?
Yes.
Question.
And that was the chairman and another victim agreed to the sentence.
Member Renahan.
So, yeah, my question is, under the Safety Act, does the judge have any discretion to hold a person who would do this?
Not with a class 3 threatening a public official, no discretion.
No discretion, because I mean, I think you do bring up a good point. I mean, I don't mind saying, hey, this is an exception, you know, we kind of haven't taken it up, but I think this is important. I think I appreciate what Connor says. In the past, there's not been an appetite. However, we've seen states of Maine, Washington, Vermont. We have a new U.S. Department of Justice has a new task force investigated 850 threats to election officials in the past year. So, I mean, as much as I don't know how much I have even appetite to keep talking about this either. I understand kind of what you're saying here, but it's real. I mean, there is a change since the election of 2020. So
And I don't
and if there is
disagree.
no discretion to hold somebody who is, you know, possibly has an issue. I mean, we know Candace Adams received an actionable threat. Person now is being held, right? I mean, he's
Correct.
in jail awaiting evaluation, right? So this touches our local elected officials. And I was not here, I was not on the board when that happened to the chairman, so I didn't really know.
Yeah.
about that.
So, I mean, I could tell you, you know, when I was president of the State's Attorneys Association, we sent a letter to the Supreme Court Committee on Bail Reform, telling them that the state's attorneys, in theory, were not opposed to eliminating cash bail as long as there was a broad preventive detention statute with a presumption of detention in all forcible felonies. But that's not what is in the Safety Act. So under no circumstances threatening a public official would it ever qualify to be held.
I think we're all awaiting refinement of the Safety Act that hasn't come yet, right, Cheryl?
Yeah, members, I don't disagree with you.
I'm
This
just saying that
cash
I
bail
know-
thing is not,
Our state's attorney has tried for years. I know the other side of the aisle has tried to get reforms on the safety bill and they haven't seen the light. They're on third reading, right? So it's already passed. So I don't think anything's gonna happen
I mean, there's
before 2023 unless it happens
a
in
couple weeks
veto.
left, April 8th, you know, is from the adjournment date.
But there's no bills that have been forwarded.
Not
on it.
yet.
other
Yeah,
questions?
and, you know, let me say too, I mean, you know, I would certainly support a penalty enhancement for threatening public officials. There's a number of crimes I think are deserving of penalty enhancements. But I just know the reality of trying to get it passed is virtually impossible right now.
Do you think the appetite would be a little bit greater because the House of Representatives knows that their colleague, Representative Conway, was threatened? Or is it still not?
Honestly, not from what I've seen. I mean, we're trying to get an extortion bill passed. Illinois does not have an extortion law. We're one of only a few states that don't have one. And we've been trying for 7 years to get that through. It's passed the Senate unanimously, but it's never been called in the House. And probably not going to be called this year.
Briefly, just sorry not to interrupt, in order for a bill to get called into the House on a penalty enhancement or criminal action, and correct me if I'm wrong, Cheryl, but I believe it has to go through the Restorative Justice Subcommittee, which is very active in not hearing penalty enhancements. Again, the state's attorney points out that it's been a hallmark of the governor's and the legislature's policy plan to move away from traditional penalties and seek a more restorative approach to justice. But in doing that, they're also shutting the door pretty firmly on penalty enhancements. And as I'm sure your legislative lobbyists will tell you, if you keep focusing on dry wells and dry issues, you're never going to get anything accomplished down there. So we have to turn our attention to things that are going to make a material impact that we can work with people on and that we can have some buy-in on.
I guess it is encouraging. It seems though that most of these people that have made threats against when they go to trial, they've been found guilty at least and have had some recourse against them, correct?
Well, right, the one case was a trial, the Bona case was a jury trial.
Mhm.
The Montgomery case was a plea.
Okay, please, right,
That
so,
was a
okay.
plea into my case.
And then I know Bob Schulstrom was threatened a long time ago too, and I think that gentleman served some jail time.
I'm pretty sure, I believe that was a plea guilty
Oh,
to.
pleaded guilty too, okay.
Yes,
Yeah. She
yes. And then after he
threatened
got
a lot
out,
of people and a lot of phone calls.
the threats continued. They stopped for a while, then a few years later, I know those threats continued. I mean,
Thank you
look,
so much.
we take them very seriously.
Yeah.
And we, you know, when we charge these cases, we do a press release and we're consistent about it.
Cash bail tends to keep the poorest in jail. But I am with you, and if you can figure out a path, I would work with you.
I think
because-
the problem with the bill is there's no leeway or anything. You're not giving judges the right to do things. You're not giving prosecutors the leeway in certain cases. I mean, it's cut and dry. Don't you think, Bob? Where, I mean, you really don't have that leeway and judges don't have leeway in sentencing anymore.
And
Where
that's
they
the
have
problem.
that ability to, where there's, special cases or special circumstances, they can do that. It's kind of cut and dry now. They've taken it away. The state's taken it away from our prosecutors and our judges to make determinations on their own. That's how they were elected, on their own. They've kind of taken away and kind of handcuffed them on a lot of these.
And that's the fine line that I would love to work with you on, if you could find a way that if somebody was threatening any of my colleagues, I would want them behind the bars. I would want them behind
Well, I
bars.
threaten a lot of our guys, but that's not, we're the same difference.
So where do we go from here? What is the?
I mean, the most immediate issue is the elimination of cash bail, January 1st. And the changes that need to be made to the statute, the preventive detention statute. Because the law that was passed has different standards in the same statute. In some areas, it says in order to hold someone, and this, again, this is only on a limited number of cases. Judges can hold them if they're a threat to a specific person or the community. In other places in the law, it says they can only hold someone if they're a threat to a specific named person. And every time the case is up, a judge will have to make that finding that they're a threat to a specific named person. So it's unclear,
Excuse me.
what the standard is, but there are a number of offenses, including robberies, burglaries, really any offense where you can get probation outside of the domestic area, where judges will never be able to hold someone. And that's contrary to what the current law is in New Jersey, which eliminated cash bail 5 years ago. But their judges have broad discretion to hold people
And ours don't.
under the law that was passed.
Gotcha.
Correct.
Can I ask you what the fine line is between a threat and a real threat? That you described early on. in the meeting?
It's the intent. It's the either intent to transmit it as a threat or to prove that the person transmitting the threat knew that whoever received it would take it as a threat. And that's just something we have to prove.
So I don't know if you can even answer this question, but so with Representative Conroy's situation, are you guys going through all of the phone calls, or not you, that would be law enforcement, right? Going through all the phone calls and trying to ascertain which calls are a threat or which calls are a real threat?
So, it's a pending investigation, so I can't comment on the specifics, but I can tell you this. Any investigation that we get involved in is very thorough, and we go through everything. And we're working with the state police.
There's a million other, as a reporter, there's a million other questions I want to ask you, but I know you get that correct.
That I probably wouldn't be able to answer.
Okay. Other questions or comments or thoughts?
But I agree, anybody who threatens elected official, if it's any of you, any of our colleagues, any of our county, any of our state legislators, anybody, they should be dealt with
Even our
swiftly.
employees. I mean.
Our
Our employees too. I
And
think
our
employees
families, I
our
mean,
employees are covered a little differently, aren't they? Probably no.
It's public official includes, it does not include employees.
Generically, it includes specific
It
classes.
includes, duly appointed assistant state's attorneys, assistant attorney general, appellate prosecutor, sworn law enforcement or peace officer, social worker, caseworker, attorney, or investigator employed by Department of Healthcare and Family Services, DHS or DCFS, or the Guardianship and Advocacy Commission, or an assistant public guardian, attorney, social worker, case manager, or investigator employed by a duly appointed public guardian. It does include immediate family, which means spouse or child or children.
But not the administrative assistant who may pick up the phone for any of those
Right.
people.
Now, I mean, that doesn't mean that depending on what the threat is, it could qualify as an intimidation. It could qualify as a disorderly conduct, an assault, potentially, depending on what is said and how it's said. So there could be other crimes that might apply outside of threatening a public official.
Other questions, comments? Member Chaplin, did this answer all of
Thank
your
you so
questions?
much. Yes, provided a lot of good information. I took a lot of notes and might have some ideas.
Okay.
Thank you
Sure.
very much. Appreciate it.
My pleasure.
Thank you so much for your
My
time.
pleasure.
Really appreciate it. Any old business?
Well, yes.
Okay, I saw Ms. Members.
Just a thank you that Water Commission bill passed the Senate 54-0, so it's on to the House now.
Awesome.
And I had asked that we consider supporting the gun safety storage legislation at the state. So I don't know, do we have to put that on the next?
Right, it was too late, yeah.
Okay, so if we can add that to our next
But
agenda.
are they almost done in Springfield for the? Would they get
Probably
that
in
in
2 weeks,
April?
it may have already passed. It did pass the.
Oh, it did
House.
pass. Oh, great.
So it might be
great.
passed in 2 weeks. We can look.
But as I said earlier, if any member has anything that they want to.
But if it's not passed,
on
we
this
can-
committee,
Okay.
I'm happy to do it. So do you want it on the next agenda? for
If it's
the-
not passed, yes.
Okay, thanks, Sharon.
Oh, but it just, when did it pass the House today?
Last week,
Last week? Oh,
because it was
great.
third reading deadline last week, so
Oh,
that's why.
great. Good, 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 good.
All right, any other old business? New business? Okay, without objection, we are
Thank you.
adjourned.